Okay, got to click, got it. Thank you. So we're now recording and welcome. And in a week, we're going to have somebody talking about bees. In 2 weeks, we have somebody talking about nutrition. So that'll be very exciting. Today we are, I think I'm going right into this. Today we are honored and privileged to have one of our own members talk on the Teach Me program. The Teach Me program is where one of our own members tell everybody else in the club about something at which they have expertise, but perhaps the other members of the club don't have expertise. I can honestly say, and I'm glad I can honestly say, that I have very little expertise in what we're talking about today. In Minnesota, we have sentencing guidelines. And some states, I believe, don't have this, but we do. And so if somebody commits second-degree murder, they're going to jail for between this months and that many months. And that's a judge may go to the short end or the long end of that, but it's up to the judge to decide. So with showing how little I know about this, without further ado, I'm going to introduce Judge Karen Asphaug. Karen and I have known each other since she was 16, believe it or not, when I interviewed her and her mother to be an exchange student. Little did I know at that time that she was going to become an exchange student, and not only that, but be sent to the same town I went to. So I ruined the whole exchange experience for her by having been there before her. I'm sure I did a lot of things they talked about, and she's been very polite and not told me exactly what they told her. But anyway, we didn't go to the same high school because they switched buildings between myself and her, but essentially in the same town. So kind of interesting. I am crossing my fingers and holding my thumbs that I will be heading to that town in August of this year. So we'll see what happens. So anyway, without further ado, Judge Asphaug is now retired. So she's what's known as a senior judge. She has told me many times she's retired and that she is fully retired, and yet she seems to work 3 to 5 days a week. Karen, I'm going to turn over to you.
Thank you. Okay, I'm going to share my screen. All right, is everyone able to see the screen? Great. The topic today is sentencing. You be the judge, criminal sentencing policy and practice. Now, let me see here. There we go. So, why is sentencing important? How many times have you wondered what happened here? When you read about a criminal sentence in the newspaper, or when you hear about it on the news, and you wonder, wait a minute, how did that happen? Or how many times have you thought, oh, thank heavens, phew, when learning of a sentence? Like, for example, last week, when the 3 men were sentenced in connection with the Ahmaud Arbery murders, and they received, 2 of the 3 received life without parole, the possibility of parole, and 1 did receive a life sentence. The 3rd received a life sentence. And I think there was this collective sigh across the country with an understanding that justice had been done. And we hear the refrain, "We want justice." That is a common refrain that we hear these days, often spoken in the aftermath of a heinous event, a horrible event, an event that arouses emotion in the part of the community, of course, in the part of the victim's families, but in our society at large. And I think that when people say at times like that, "We want justice," it has a very specific, very personal meaning to the person who's uttering those words. Justice is nuanced, and justice is a concept that we strive for, that we want, that there are individual components to the notion of what justice is, and it incorporates concepts along a spectrum from retribution all the way to mercy and to mitigating circumstances. Sentencing is, and when people talk about justice, they're talking not only about the process of the trial, the due process, but they're talking about the sentencing. And sentencing is critical to legitimizing the rule of law. It is absolutely critical to either maintaining or undermining society's confidence in its justice system. Of course, sentencing is important to the victims of the offense, to the offenders, and to the community as a whole. There are certain recognized purposes of sentencing. The first is accountability. And accountability is a fancy way of saying punishment. It is simply a fancy way, yeah, of saying punishment. Accountability is, my dog is making noises in the background, I apologize. Accountability is a primary objective of sentencing. Rehabilitation of the offender, again, is a primary purpose of sentencing. And I think that all of us, the community, and I've heard so many victims in court speak over the years, and rehabilitation is such an important concept of justice for them. One of the other purposes of recognized purposes of sentencing is deterrence. And we break that down into specific deterrence and general deterrence. Deterrence means to provide an incentive in the case of specific deterrence, an incentive for that particular offender to refrain from future unlawful behavior. General deterrence is to provide an incentive to the public at large to refrain from illegal behavior. A really common example of general deterrence at work is the change that we've seen in DWI sentencing. Back in the day, it used to, when I was growing up, you heard stories, or when I was a young lawyer, you heard stories often about someone being stopped for a DUI, and the local law enforcement officer would know that person and would simply take the person home and say, now sober up, leave the car where it is, and go back and get the car tomorrow and just knock it off, straighten out, fly right. That, of course, that does not happen anymore. There's been a sea change in terms of about DWI enforcement and DWI laws. And the effect of effective DWI prosecution and sentencing is that there's been a general deterrence. People are aware of what will happen to them. They are concerned about being punished for DWIs. They're concerned about losing their license, going to jail, having high insurance rates. So consistent sentencing on DWIs provides a general deterrence to otherwise law-abiding people to refrain from illegal conduct. Incapacitation is a purpose of sentencing. We incarcerate people to incapacitate them, to prevent them from committing future harm. Restitution is victim reparation, and that is a purpose of sentencing. And the number one umbrella purpose is to protect the public. And all of those other purposes fall under that umbrella of protecting the public. So let's talk about sentencing principles. First of all, in order to ensure public trust and confidence, well, first of all, I'm going to back up. What do we value as a society? And I'm just going to invite people to chime in. Unmute. I'm not going to just lecture here. I'd really like to hear what do we value when we think about the criminal justice system and how it reflects society's values. What do we value above all else in society?
Personal safety and freedom.
Personal safety. We value life. Right? Above all, if you look at the structure, and I'll show you, we'll get to the sentencing guidelines, but you look at the structure of our guidelines, and there's only one crime that is not included in the Minnesota sentencing guidelines, and that is murder in the first degree. And it's because it's a mandatory life sentence. So the highest value we place in our justice system is on life and the protection of life. And Lindy, as you say, our personal safety. We value persons at the top tier of what we value in society is persons. And then if we go down to the next tier, what do we value? What do we want to protect?
Our property.
Exactly, our property. And you'll see that as I show you the guidelines, we value some property differently than others. So the highest tier of property that we value would be, what do you think?
Our homes.
Yes. Oh, you're so smart. Our homes. And we value our homes not only for the value, of course, for most people, it's their most significant investment, but it's where we live. By valuing our homes, we're protecting the people who dwell within them. Then we value our businesses. You know, we certainly, of course, I don't mean to diminish the importance of our personal property, but in the criminal justice system, way down on personal property is way down on the list. You know, the theft of a lawnmower, a push lawnmower, is not going to have the same severity, and I think most people would say that, as an assault against a person. So we want sentences that reflect the seriousness of the offense as society deems offenses to be serious. And we want sentences to reflect the degree of the defendant's responsibility for it. In other words, we want punishment that is commensurate with the offense. Now, society's values about this change over time, like the DWI laws. That has changed. We treat DWI far more seriously. About, I don't know, 6-7 years ago, we enacted a first-degree DWI law in Minnesota, a felony DWI, which we had never had before. And that's for persons who have 4 or more DWI offenses. And that's a reflection of society's value of that social contract of being able to go out on the road with reasonable assurance that the people you meet are going to be sober and capable of operating a motor vehicle. And so the DWI laws have become stricter as time has gone on, and other offenses have been deemed to be less serious. So for example, you may remember in the 80s, California enacted, and not just California, but other places enacted a 3 strikes law. In other words, on your 3rd felony, 3 strikes, you're out. On a 3rd felony, people were receiving extremely long prison sentences, even if that 3rd felony was a relatively minor property offense. And it resulted in terrible inequities, and those laws have been repealed. There was a time where drug offenders, and I think it's important to distinguish between those who are involved in the distribution for profit of illegal drugs and those who are convicted of possession for personal use amounts. We used to have very long sentences for repeat drug offenders, and I'll show you that we have completely revamped our criminal sentencing practice and our criminal code with respect to drug offenses in Minnesota in response to a shift in public perception about drug use, drug abuse, and how we should treat persons who have substance abuse disorders. Another principle, and this is critical, we focus on the criminogenic needs of the offender. So what on earth does that mean? Well, a criminogenic need means we try to address factors factors that are highly related to criminal conduct. And those factors include substance abuse, antisocial cognition, and we call those thinking errors or criminal thinking. An example of criminal thinking, if you were in the grocery store and you saw someone's cart unattended, and the shopper was turned and she was, picking up apples off the shelf, and her purse, she wasn't looking at her purse, and her purse is wide open and her wallet is visible, her, checkbook is visible. A person who does not have antisocial cognition, in other words, those who have pro-social cognition, would say, "Excuse me, ma'am." I just want to, or they'd stand there, or maybe they'd keep moving, but they wouldn't think, "She's asking for it. She, what a dummy. She is so I'm going to take advantage of this situation and reach my hand into her purse and take her wallet." That's antisocial. That's criminal thinking. And so that is a huge criminogenic need. I had an offender once who I presided in our drug court, in our treatment court, for a number of years, for about 5 years, in the last 5 years of my career. And I formed very close relationships with my offenders, with our probationers. And one told me, and she was poor. She was a single mom. She had all kinds of struggles in her life. She had gone out Christmas shopping, and she came to court the next day, and she had a limited pool of money to buy presents for her child. And she told me she was so proud of herself because when she pulled into the Walmart parking lot and got out of the car next to her was full of packages, shopping bags. It was like Black Friday. And she was so proud of herself because she didn't jiggle the car handle to see if she could get into that car to take the packages. And it was a stunning moment for me because, of course, I was so proud of her, and that she recognized that was how she used to think. She would have tried to take advantage of that situation, and she realized she was setting a boundary, and that was such an important pro-social step for her. So anyhow, we try to focus in on and whether the person has antisocial associates versus pro-social associates. Do they have antisocial or pro-social recreational habits? Are they employed? What are the issues in their family and marital relations? So those are some of the issues we try to address through sentencing. One of the things that when we focus in on the criminogenic needs, people come before us in the courts and they have tremendous needs. I mean, mental health is one that can also be a criminogenic need. But there's a long list of needs that people have. And the courts sometimes serve as the social services delivery system of last resort. And we cannot we cannot build into a criminal sentence the means to address every problem in every need in the life of the offender who stands before us. Many people who stand before me are high school dropouts. They have not achieved a GED. Would it be good for them to have a GED? Absolutely. Do I order someone to get their GED as part of their sentence? No, I don't, because it's not criminogenic. It doesn't lead to crime. And the question I ask myself with every sentence is, am I prepared to send this person to jail or to prison if they violate this term of the sentence? And we're not going to send people to jail because they don't get their GEDs. So we try not to build in things that may be good for the person, that may benefit the person, but really don't address criminal behavior. We focus on the risk of future harm. In other words, we use actuarial instruments. And future harm doesn't mean I'm scared of you. I'm mad at you. But we use actuarial instruments that are research-based, peer-reviewed, that give us a risk of future harm. We also recognize in the state of Minnesota that a prison bed is a scarce and a costly resource. And just so to give you an idea of this, approximately 69,000 inmates cycle through local jails in Minnesota each year. Each county has its own jail, and people whose sentence is 365 days or less serve their time in the local jail. People who are sentenced to a sentence of a year and a day or more go to prison. And so over 69,000 inmates per year cycle through local jails in Minnesota. In Minnesota prisons, and the most recent statistics I found were July 1 of 2021, so 6 months ago. We had 7,369 inmates committed to Minnesota prisons. Of those people, 6,948 were men, so about 7,000 were men, 421 were women. Getting back to the whole issue of what do we value in society and how do our sentencing practices reflect that? The top 6 offenses that result in prison commitments in Minnesota are, first, criminal sexual conduct, and 20.2% of our offenders, I'll round up and down rather than give you the points, but about 20% are committed to the prisons for criminal sexual conduct, 19% for homicide, 16% for drugs, 8% for assaults, 8% for weapon offenses, about 5% for robberies. So those are the top 6 categories of offenses that result in prison commitments in Minnesota. Of the people who are committed in Minnesota prisons, about 60% have committed crimes against persons. 16% are there for drug offenses, 8% for weapons offenses, 7% for property offenses, and 4.5% for first-degree DWIs. So that's a substantial number of people who have been sent to prison for DWI offenses. We have 608 lifers in Minnesota prisons. And of those people who are serving life sentence, and of those lifers, 149 have been committed to life without parole. The average age of a prison inmate in Minnesota is 39 years of age, and about 1,300 are over age 50. So one of the things that when I say we recognize that a prison bed is a scarce and costly resource, the Minnesota Department of Corrections has a budget for incarceration. And of course, that includes staff and programming and housing and food, but the incarceration portion of the Department of Corrections budget is $462 million per year in Minnesota. The total budget of the Department of Corrections is about $631 million. And that also includes probation services and programming, education, things like that. The top counties that result in prison commitments are Hennepin, with 26% of the commitments come from Hennepin, 11% from Ramsey, 4.7% from St. Louis County, 4.6% from Dakota, 3.9% from Stearns, and 3.7% from Anoka. When we recognize that a prison bed is a scarce and costly resource, it is also really important to understand that the offender comes from the community. And, we've got 600 lifers in Minnesota out of a prison population of about 8,000. They've come from the community, and the overwhelming majority will return to the community. And so our goal in sentencing is to provide an opportunity, for accountability, for punishment, for public safety, but to provide a meaningful opportunity for change. Other important principles in sentencing is to reduce sentencing disparity. Sentencing should be neutral with respect to race, gender, social, or economic status of the offender. In Minnesota, of prison commitments, 52% of the prison population is white, 36.5% is Black, 8.6% American Indian, 2.7% Asian, 71% is single, 12% is married. So maybe we should say marriage is a pro-social. Certainly it is pro-social. 11.5% are divorced. It's a guiding principle that sentencing is policy-driven. It is not fear or anger-driven. The primary sentencing objective, as I've said several times, is public safety. And it's important to understand that a prison sentence is the most severe sanction that can be imposed for a felony conviction, but it's not the only significant sanction available. And this strikes home the importance of meaningful probationary supervision and meaningful probation supervision in the community. We believe in Minnesota that confinement should be imposed only for offenders who are convicted of more serious offenses or for those who have longer criminal histories. If you are a thief in Minnesota, you have to work long and hard to get yourself into prison. You have to have substantial criminal history. We reserve those prison beds primarily for people who commit crimes against persons. Sentencing should be the least restrictive necessary to achieve the purposes of the sentence. And under the Minnesota law, we recognize that substantial and compelling circumstances exist that can either mitigate or aggravate a sentence. And you've got to consider those substantial and compelling mitigating and aggravating circumstances. In other words, each case is individual. We've got 4 levels of offenses in Minnesota. Petty misdemeanors. Petty misdemeanors, speeding tickets are petty misdemeanors. Possession of a small amount of marijuana is a petty misdemeanor. Petty misdemeanors are punishable by a fine only, and the maximum fine is $300. There is no possibility of being sent to jail on a petty misdemeanor. Misdemeanors include the first-time DWI, first-time low-level assault, first-time domestic assault, assuming that there's not severe bodily harm, thefts, disorderly conducts. There's a huge body of misdemeanor offenders that appear before us. Maximum punishment is 90 days in jail, a fine of up to $1,000. Gross misdemeanors include the second and third DUIs, and repeat assaults, repeat domestic assaults. The maximum punishment is up to 1 year in jail, a fine of up to $3,000. And felonies are the serious offenses where the punishment is a year and a day or more in prison. We have a sentencing guideline system in Minnesota. You hear about other states where someone is sentenced to 0 to 7 years for a particular crime, or 3 to 10. And those are what are called indeterminate sentences. We do not have that in Minnesota. We have determinate sentences. When a person is sent to prison in Minnesota, they are sent for a specific term of months. And I'll show you the sentencing guidelines and how we get there. Without getting too far in the weeds, a person stands before us for sentencing either as a result of a plea of guilty or a conviction following a trial. Sometimes there's a way to resolve a case without a plea of guilty in Minnesota, but I'm not going to get too far in the weeds. The overwhelming majority of cases are resolved through plea negotiations. And sometimes the defendant will enter what's called a straight plea. I'm just going to plead straight up to you, judge. I'm going to make my pitch for sentencing. The state can make their pitch for sentencing, and the judge will decide. If there is a conviction following a trial, there is no plea negotiation. The judge decides the sentence. Many people feel that plea negotiations are, that there's something wrong with it, that there's something maybe dirty about that. Only 5% of the case, I can tell you that the criminal justice system would come to a screeching halt if we did not have effective plea negotiations. Only 5% of the cases that are filed go to trial. 95% of the cases are resolved by means of a negotiated resolution. So for example, I mean, Derek Chauvin went to trial in state court on the homicide case, but he was also charged in federal court with a civil rights violation, and he entered into a plea negotiation on that in federal court. Prosecutors understand their communities, and they understand the strength and weaknesses of their case. And prosecutors and defense attorneys have a sense of, like I said, how strong the case is, where the evidentiary weaknesses are, where the litigation risk is, and plea negotiations tend to be a very effective way of resolving cases. Judges have the ultimate authority and the ultimate discretion in whether to accept or reject a plea negotiation. So someone stands before us for sentencing. We order in felony cases something called a pre-sentence investigation. It is done by the probation department. It often includes a psychological evaluation. It often includes a chemical health evaluation. We may have gambling assessments, domestic abuse specific assessments. When the pre-sentence investigation is concluded, there's a victim impact portion, there's a financial portion, restitution portion of the history. The pre-sentence investigation results in a report that can be as short as 7 pages in length, individually spaced, a single-spaced 7-page report that goes back to the family of origin, where the person went to kindergarten. It can be a 20-page report, depending on the case and the individual defendant. It is a very comprehensive, very thorough document that provides the judge with greatly detailed information about the offender and the offense. And it includes a detailed analysis of the prior criminal history of the defendant. And it is reviewed, it's very, very helpful, and it is reviewed prior to the sentencing hearing. At that hearing, the state appears, the defendant appears, of course, with his, and I generally use the term he when describing the offender, and you can see from our statistics that the overwhelming majority of people who are sentenced to prison for felony offenses are male. Of course, women commit crime, but I generally, my default is to use male pronouns when talking about offenders. So he comes in for hearing, for the sentencing hearing. State is present through the prosecutor. The victim has the right to be present. The victim has the right to read a victim impact statement or to make a victim impact statement. And the pre-sentence investigation includes something called a sentencing worksheet that's based on the Minnesota sentencing guidelines. So I'm going to show you now the Minnesota sentencing guidelines. We have 3 grids, and you can see that this is our, what we call the standard grid. Starting at the bottom, a severity level 1 offense is the lowest level of offense, that felony offense. Going all the way up to a severity level 11 which again is murder and intentional murder in the second degree. Because murder in the first degree is a non-guidelines offense. And in between, you can see, if you start from top to bottom, how we rank order offenses. And you can see we move from crimes against persons to crimes against property. And I think it's really interesting. There's a commission that ranks offenses, a sentencing guidelines commission in Minnesota that consists of judges, lawyers, members of the community, probation officers. I'll be very interested to see whether the assault in the fourth degree, which is assault of a peace officer, and fleeing a peace officer, whether they move up the guidelines based on public safety concerns. It'll be interesting to see what happens. They constantly meet and review and re-rank offenses. So that's the standard grid, and you can see along the left side of the grid is the ranking of in severity of the offense. Along the top is a criminal history score. And so as a person has more criminal history, more conviction, and by criminal history, I mean convictions, not arrests, but convictions for crime, the punishment goes up. And there is a number. There is a number, and then there's a range of numbers. And those are the presumptive sentences. So let's look at felony DWI, which is a severity level 7 offense. And let's say the person comes in with a criminal history score of 3. The presumptive range would be from 46 to 64 months. And a judge can sentence anywhere from 46 months to 64 months without departing from the guidelines. The mid-range is 54, so that the number that is the standalone number is the middle, we call it the middle of the box. And most crimes would be sentenced to the middle of the box, and you could take there's wiggle room though built in. The gray shaded area are presumptive probation sentences. The white shaded or the white area, those are presumptive prison commits. You would presumptively go to prison and be sentenced to the Department of Corrections for prison incarceration if you fall in the white area of the grid. You would be presumptively placed on probation if you fall in the gray area of the grid. But again, a judge can depart and place someone on probation who would presumptively go to prison, or send someone to prison who would be presumptively on probation. So we have a standard grid. We also have a sex offender, or this is the drug offender grid. And we have a whole range, again, of drug offenses. And we have largely reduced the sentences for drug offenses in Minnesota. We had substantial drug sentencing reform in 2015. And this is the result of that. Oh, I missed, because we also have a sex offender grid. So 3 grids, the standard grid, the sex offender grid, the drug offender grid. And with sex offenses, we distinguish between cases involving sexual contact, which is touching, versus sexual penetration. And we distinguish whether there's force or coercion involved. And you can see we rank order these from low to high. So if we place a person on probation, we can sentence that person up to 365 days of local jail time on a felony. And we may choose to place someone on probation because they would receive treatment opportunities in the community that might not be available in a prison sentencing. Sometimes an offender can be supervised for a longer period of time, up to the statutory maximum of a sentence with a probationary sentence. And we have those opportunities to address that criminal thinking, that antisocial thinking, through dialectical behavioral therapy, drug and alcohol treatment, gambling treatment, domestic abuse treatment. And we have established treatment courts in Minnesota that address the needs of high risk, high needs offenders who would otherwise be in prison, but who can be treated in the community with drug court, family treatment court, and veterans court. These are miracle working courts, miracle working courts. So let's talk a little bit about you be the judge. So here, I've got 3 case scenarios for you. Defendant is a 24-year-old female who was arrested driving her boyfriend's car. And in that car, on board, were a kilo of methamphetamine. That's a lot. That's not a personal use amount. And her toddler. She has no prior criminal record. She pled to first-degree controlled substance crime, which is a presumptive prison commit. Her lawyer is seeking a departure from the Minnesota sentencing guidelines, and the state is asking that she be sent to prison. So let's talk about this. Do you think it's proper to consider her status as the sole caretaker of the child as you formulate your sentence?
Well, she
Happens all the
pled-
time. Happens all the time. Judge, my client is a single mom. My client is, he's got.
She said she knew they were in the car, though. She pled guilty, right?
Well, she pled guilty. Yep. I've got another question about that. But for instance, should we consider the fact that she's the sole caretaker of a child? The starting point is the presumptive sentence is 65 months.
Over 5 years.
Right. She would get a third off for good time. But still, that's a long time. So, I mean, a kilo of methamphetamine, I don't even know what the street value is. Let's say it's $100,000, more than $100,000. It's significant. It's a significant amount of methamphetamine. This is a big dealer amount of meth. So would you consider, I mean, you're the judge, do you consider the fact that she's got a toddler? She's a single parent of a toddler.
Probably not the way you want me to.
I don't, this is the stuff that tugs, it tugs at your heartstrings, right?
Well, I feel like, why would she have a toddler in the car with that? Right? She's clearly putting her child at risk for violence from somebody else who might want that. I mean, it just seems so wildly irresponsible.
I think we'd all agree that it is wildly irresponsible. It shows the ripple effect, though, of crime, that families are affected, children are affected. It shows just how that ripple effect. The Minnesota sentencing guidelines say you can't consider. I mean, that's a factor that's, are we going to treat a single person without children differently than we would someone who has children? The Minnesota sentencing guidelines would say you cannot consider that in your sentence. That's not a basis to depart.
That's good.
Is it proper to consider her lack of a prior record in your sentence?
Yeah.
I think so.
It's built into the guidelines.
Yep.
Because the guidelines so that in and of itself is not a mitigating factor because it's already built into the guidelines. She comes in with a 0 criminal history score. And with a 0 criminal history score and this level of offense, the presumption is she goes to prison.
Wow.
So she doesn't get a double break because she has a clean record. What if she had no knowledge of the presence of the drugs?
Do you need to consider where the drugs were? Were they in the trunk? Were they in the back seat? Were they next to the toddler? Do you need to know that before you can answer that question?
Well, you would know that. I mean, you would know that. I mean, by the time you get to sentencing, you're certainly going to know where were the drugs. I mean, are they, if they're under her feet, that argument's not going to fly, right? But if it's in the
But
trunk,
how
we know
can she
the
say
boy-
she doesn't know there are drugs in the car if she pleads guilty to the drugs in the car?
Well, she may be doing it because she's got a boyfriend who's threatened her.
Well, the first thing I
Because
can,
if you don't take the heat on this, I mean, it could be that she is in an abusive relationship. And if you don't take the heat on this, I know all kinds of bad actors who are going to come after you. And she may have pled guilty to this offense for reasons that we may not understand. But if she claims that she did not know that the drugs were there, that is, of course, a defense. It would be a defense to say, I didn't knowingly possess it. If she did not knowingly possess it, that is a defense to this crime. It is a defense. Offense specific information can be used for something called a durational departure to say, okay, that's mitigating. So I'm going to reduce the number of months, but we give probationary dispositions for offender specific conditions. We distinguish, you can see how complex sentencing is. We distinguish offender character specific mitigating circumstances from offense specific mitigating circumstances. So when I say offense specific, it means the degree of the defendant's involvement in the crime. So what would you want to know? Let's say your heart goes out to her. You believe that she's got a bad actor boyfriend. I mean, there's a whole lot of women who have bad actor boyfriends. You believe she's got a bad actor boyfriend, and you believe that he's probably the source of the drugs. What would you want to know to determine whether she's amenable to probationary supervision? Because there have to be substantial and compelling circumstances to depart from the guidelines. And it is a substantial and compelling guideline if she is particularly amenable to probationary supervision.
Is he the father of her child? Is she going to spend more time with him? Do they live together?
Right. You might want to know, has she cut ties with this guy, right?
Yeah.
And you might want to know, has she had a chemical health assessment? What does it say? Is she chemically dependent? Because so often people who are chemically dependent also are involved in the distribution of narcotics. But if she's chemically dependent, and has she taken steps to actually get herself into a treatment program? What is she doing? What is she doing to show you I'm willing to straighten out and fly right?
Karen, do you consider, like, is she employed? Does she have good care for her child? Do you look at that kind of stuff? Is she a functioning member of society?
You can't, employment in and of itself is not a grounds for a departure, but it is a grounds to consider when you consider the stability of this person in the community. What kind of community support does she have? The best possible, the most stable stool is a three-legged stool. And for an offender to do well in the community, that three-legged stool has to be the offender taking responsibility and accountability and making change, the community supporting that offender, and also victim buy-in. Now there's no victim here, but I try to think of a three-legged stool and how stable is that stool? How stable will this person be? I think that in a case like this, a judge really would look at her and try to, I mean, if she's living in a drug-fueled lifestyle, her child is not, this is harmful to the child. And a judge may think you're going to be better off in prison. You can get the treatment you need in prison. You can get some vocational training there. I'm going to send you. Or it's just simply an amount that's inexcusable. And some judge, and you're going to go for a kilo of meth, you're going. It's a scourge to our community, and you are going. And the legislature and the Sentencing Guidelines Commission have said this is a very, very, very serious offense. Some judges, depending on the individual defendant, might find that she is amenable to probation, and they might give her a chance in the community. They would certainly hold a prison sentence over her head and place her on probation and ship her if she violates her probation. So that's one case scenario.
Karen, I have to tell you that it's 5:33.
Okay. Do you want me to quickly go over these
I think
scenarios?
how about you do an overall summary and then we'll do the 4-way test.
Okay. So, okay, in this case, this one we might, defendant is convicted of 2 counts of aggravated robbery, that's robbery with a weapon, and 1 count of fleeing a peace officer in a motor vehicle. The flight occurs immediately following the robbery. The robbery involved 2 victims being robbed of personal belongings at knife point. Defendant stands before you at sentencing with 2 criminal history points. Question, are you willing to consider placing this person on probation?
No way.
I think most people would say that.
Yeah.
Here's the interesting question. Does it make any difference if the victims are innocent victims? You know, 2 kids that are going into the movie theater and somebody comes up to them, sticks a knife in them, takes their cell phones, and then flees. You know, they're pure innocent victims versus victims who are naughty victims. You know, it's a drug deal gone south.
I don't think it matters.
Yeah.
There's too much carjacking going on right now.
Yeah.
I'm biased.
Yeah. This is one I think that most community members would say, this is why we have prisons, right?
Yeah.
This guy has to go. Okay. This was the last, on my very last day as a full-time judge, this was the case that I had. The defendant is convicted of aggravated assault, which is assault with a dangerous weapon. The incident occurred, oh, I just lost it. Oh, what did I just do? The screen.
Try share screen.
Here, should I just read it to you?
Yeah.
Okay. Defendant is convicted of aggravated assault with a dangerous weapon, following an incident that occurred at his mental health group home. Defendant has a long history of schizophrenia. Defendant was committed to the Minnesota Security Hospital as mentally ill and dangerous for a previous offense. And he responded well to treatment and was provisionally discharged to the community with placement in the group home. Defendant began to decompensate. His behavior and mood became erratic. Knowing that he was about to be sent back to St. Peter to the security hospital, he bought a rifle and he placed it in the trunk of the car. When 2 police officers responded to a call from the group home, defendant went to the car, grabbed the rifle, and opened fire on the officers in the front yard of the group home. Now, for purposes of your decision, defendant, although he suffers from a mental illness, and I do need to say that most people with mental illnesses, including schizophrenia, are far more likely to be victims than perpetrators. Although he suffers from a mental illness, he is competent to proceed and he doesn't claim a mental illness defense. Do you sentence him to prison? The presumptive prison, I mean, he's shooting up the place. He's shooting at police officers. Do you send him to prison or place him on probation with the understanding that he'll be returned to the security hospital.
He used his gun. I mean, that sounds way worse. I mean, I can't imagine it's just probation.
If it was probation, he's going to be shipped back to St. Peter. So he'd be behind razor wire at St. Peter. He'd be in a secure setting in St. Peter, well, for a period of time. But, you know, I can tell you my heart went out to this man because of his mental illness. And he was scared and frightened. And my heart went out to him. And by the time I saw him, he was back on his meds. He was stable. And I sent him to prison. You cannot shoot at police. I felt very, very strongly. You just don't get to get out your long gun and start shooting at police officers in the front yard in a community setting. That the risk to the public, the risk to those officers was, I mean, it was amazing. And I have to say, it was amazing that they didn't kill him. He came out of it alive. They didn't shoot him. Another squad, they were able to get him down, and they were able to subdue him without firing at him. And, but I sent him to prison. And then he'll be committed and he'll go back to St. Peter.
Yeah.
So that's the presentation.
That was so good.
Really well done. Really well done, Karen.
My God, that's a hard job. I always knew it was hard.
This is amazing. It was so interesting.
Thank you.
Wow.
But you know, I think people who serve as jurors, I don't know if any of you have served as jurors, what jurors tell me throughout my entire career is this was the hardest thing we ever did, and it was so important. I mean, it was so hard and so worthwhile and so important, and we have such respect for this system. And they come away with a newfound knowledge and appreciation. And I think it's very easy to watch the news and think, what was that? How can that have happened? And there's so much that goes into it. There's so much assessment and evaluation and diligence that goes into the sentencing process.
So, Karen, my quick question is, thank you, Chris-Ann. Is Minnesota really different from other states?
Well, in the sense that we have determinative sentencing, and it's very, very transparent, very open. We have not had the prison crowding. Many other states have had these very long sentences, and they end up with operating under federal consent decrees, and people are coming in the front door and they're going out the back, and that does not happen in Minnesota.
Okay, in the interest of time, Karen, thank you very much. Really learned a lot. Of course, because Karen and I talked a lot, some of this is in general, she's talked about it with me, but not on these specific cases. So it's very interesting to me. I hope we all learned a lot. We're going to do the four-way test, and then we're done with the four-way test. Chris-Ann, would you stop recording, please? At the end of the four-way test. So let's together unmute ourselves and read out loud the four-way test. And this is the four-way test of the things we think, we say, and we do. Number one, is it the truth?
Is it the truth?
2, is it fair
Is it
to
fair
all
to all
concerned?
concerned?
3, will it build
Will it build goodwill
and
and better friendships?
And 4, would it be
Will it be
beneficial to all
to all
concerned?
concerned?
So thank you very much. Chris-Ann, stop recording, please. And I'm glad everybody's here. Thank you for coming today.